Hello, torts fans. This Practice Perfect review discusses the duty element in claims of negligence. In many, if not most, common cases of negligence, the duty element does not present much of an issue. This is because an actor ordinarily has a duty to exercise reasonable care when the actor's conduct creates a risk of physical harm. Thus, in a simple case where a person negligently creates a risk and an accident results from that risk, the injured party will have no problem establishing the duty element in an action against the wrongdoer. In short, when an actor creates a risk of physical harm, a duty of care is almost always attached. Conversely, tort law makes equally clear that an actor whose conduct has not created a risk of physical or emotional harm to another has no duty of care to the other unless a recognized exception creating an affirmative duty is applicable. So, if Abigail is boating on a lake when she sees Lee, a stranger, flailing in the water and crying out for help, she has no duty to come to Lee's aid, even if she could easily do so without endangering herself. This so-called no-duty rule is a classic fixture in the common law of torts. In essence, we have two complementary principles of duty. One establishing that duty attaches to the creation of risk, and the other, the no-duty rule, establishing that an actor has no duty of care to another when the actor has not created a risk of harm to the other, unless a recognized exception applies. Let's have a look at the exceptions to the no-duty rule. Courts will recognize an affirmative duty of care that is not directly attached to an actor's negligent imposition of a risk of harm in 5 general categories of cases. And by the way, it must be a court that recognizes this because the existence of duty is generally regarded as a question of law. The 5 generally recognized exceptions to the no-duty rule are prior innocent or tortious conduct creating risk of physical harm, statutory duty, special relationship to the plaintiff, special relationship to the source of risk, voluntary undertaking or taking charge. Let's explore each of these categories one by one. The first category is arguably not so much an exception to the no-duty rule as it is a slight extension of the basic rule that says that duty always attaches to risk creation. The prior conduct rule says that when an actor's prior conduct, whether it was tortious or innocent, creates a continuing risk of physical harm of a type characteristic of the conduct, the actor has a duty to exercise reasonable care to prevent or minimize the harm. Consider the following variation on the case of Abigail and Lee. Suppose Abigail and Lee are friends and they are out on the lake on a small motorboat with Abigail at the helm. Abigail sees a large log ahead and steers sharply to avoid it. At that precise moment, Lee unexpectedly tries to stand up to stretch his legs. Abigail's sudden change of direction causes Lee to lose his balance and fall overboard. Lee, who is not a good swimmer, flails in the water and calls out to Abigail for help. What is the factual difference between this case and the earlier case of Abigail and Lee that is most relevant to Abigail's duty of care here? The most important relevant difference is that in this case, Lee's current predicament was caused by Abigail's actions. Abigail's prior conduct of steering her boat in a sudden manner was not tortious, as she was reasonably trying to avoid running into the log, and she had no reason to know that Lee would stand when he did. Still, it was her action that caused Lee to fall overboard and placed him at continuing risk of drowning, which are both characteristic consequences of sharply changing a boat's direction. Abigail therefore has a duty under the prior conduct rule to render reasonable aid to Lee, such as throwing him a flotation device. The second source of affirmative duties of care is statutory enactments. In a few jurisdictions such as Vermont, Rhode Island, and Minnesota, state legislatures have passed statutes that impose a limited duty on actors to provide reasonable assistance to persons in peril if they can do so without significant risk to themselves. There are also statutes that create specific duties to act in particular limited circumstances, such as a duty on the part of certain classes of actors to report child abuse or other crimes. Where such a statutory duty exists, a court may rely on it as a basis for recognizing an affirmative duty of care in a negligence action brought by a plaintiff whom the statute is intended to protect. The next category of cases where courts will recognize an affirmative duty to act is where the defendant had a special relationship with the plaintiff. What constitutes a special relationship varies from jurisdiction to jurisdiction. According to the Third Restatement of Torts, courts have recognized the following as special relationships that give rise to a duty of care: common carrier with passenger, innkeeper with guest, business with persons lawfully on the premises, employer with employees, school with students, landlord with tenants, custodian with persons in custody. Let's see how the special relationship exception might work using an example loosely based on an illustration in the Third Restatement. Scott is dining alone at Angelo's Bar and Grill when he clutches at his chest and tells Fred, a stranger sitting at the next table, that he is having a heart attack and asks for an ambulance. Fred pretends not to hear Scott and does nothing.
Love you.
Julia, who happens to be Scott's employer, is also in the restaurant at a nearby table by coincidence. She overhears his plea for help, but does nothing. Angelo, the owner of the restaurant, notices Scott in obvious distress, but ignores him for 10 minutes before finally calling an ambulance. The delay results in Scott suffering more serious injury than he would have if medical assistance had promptly been requested. If Scott sues Fred, Julia, and Angelo, which, if any of them, will be able to avoid liability by asserting that they owed Scott no duty of care?
I said love you to Baba.
The answer is Fred and Julia will be able to argue successfully that they owed Scott no duty of care, but Angelo will not, because Scott has a special relationship with him: business with person lawfully on the premises. Fred and Julia can both successfully argue that they owed Scott no duty of care because they did not engage in risk-creating conduct toward Scott. Although Julia is Scott's employer, their special relationship does not give rise to a duty of assistance on these facts because they are only at the restaurant together by coincidence, and Scott's heart attack is not a risk that rose within the scope of their employment relationship. Angelo, however, cannot invoke the no-duty rule because he and Scott were in the legally recognized special relationship of a business owner to a patron on the premises. Angelo therefore owed a duty of care to Scott. Keep in mind that in order to win the lawsuit, Scott would still have the burden of proving breach of duty, actual and proximate causation, and damages. The next source of affirmative duty is the existence of a special relationship between the defendant and another party who poses a risk of harm to the plaintiff. Remember that in a standard case where no special relationship is present, a defendant has no duty to intervene if another party imposes a risk of harm on the plaintiff. If the defendant sees a mugger attacking the plaintiff in an alley, tort law imposes no duty on the defendant to come to the plaintiff's assistance or call for help. But if the defendant is in a legally recognized special relationship with the person who poses a risk of harm to the plaintiff, the defendant does owe the plaintiff a duty of care. Such a defendant is sometimes said to have a duty to protect the plaintiff from the risk of harm originating from the person with whom the defendant has the special relationship. The Third Restatement provides the following list of special relationships that courts have recognized as giving rise to an affirmative duty of care to a third party: parent with dependent children, custodian with those in custody, employer with employee when employment facilitates employees causing harm to third parties, mental health professional with patient. Perhaps the most famous example of a case in which a court recognized this type of affirmative duty is Tarasoff versus Regents of the University of California. There, the California Supreme Court held that a psychotherapist who determines that a patient poses a serious danger to a specified third party has a duty to exercise reasonable care to protect that potential victim from being harmed by the patient. The court noted that what is required to satisfy this duty will vary with the facts of each case, but possibilities might include notifying law enforcement authorities or perhaps even warning the victim directly. The final category of cases in which a defendant may owe a plaintiff a duty of care with regard to a risk that the defendant did not create is where the defendant either voluntarily undertakes to assist the plaintiff or takes charge of the plaintiff in a rescue situation. If a defendant voluntarily undertakes to protect or rescue the plaintiff from harm, the defendant must exercise reasonable care in doing so and has a duty not to worsen the plaintiff's position. Suppose that David and Theo both notice that Peggy, a stranger, has just badly sprained her ankle and is barely able to walk. She asks them for assistance crossing a wide and busy street. Theo ignores Peggy and walks away. David volunteers to help and takes her halfway across the street, but then runs off and leaves Peggy in the middle of the road when he realizes he's late for an important meeting. She is unable to reach the sidewalk before the traffic light changes, and she is struck by a car. In an action by Peggy against David and Theo can clearly invoke the no-duty rule. David, on the other hand, probably cannot plead no duty. Under the traditional taking charge doctrine, even though David had no duty to help Peggy in the first place, once he took it upon himself to take charge of Peggy's situation and help her, he had a duty to exercise reasonable care in doing so. Because David took Peggy to the middle of the road and just left her there, he may be liable for putting her in a worse position than if he had not rendered any aid. Finally, almost all states have enacted Good Samaritan statutes that immunize various types of voluntary rescuers from claims of ordinary negligence. These statutes require plaintiffs seeking recovery for injuries caused by a voluntary rescuer to prove gross negligence or worse. And that concludes this Practice Perfect review. Thank you for tuning in.